We're live.
All right. This is Senate Judiciary. It is Friday, April 26, 2024, and we are discussing this morning's agenda. Unfortunately, there's been a few changes in the agenda. Our legislative counsel is out with COVID and is too sick to even testify remotely. And we wish Ben well in getting his health back. And we do have witnesses scheduled at 10:15 for H-876. And we're changing the agenda slightly to kind of go over some of the high points of 876 for the committee until 9:15. And then 9:15, Michelle Childs, legislative counsel, has generously agreed to try to fill in and go over some sections of H-72, which is a bill that has to do with opiate settlement funds and how they're used to deal with the opiate crisis. And one of the more controversial sections is a safe injection site section that provides immunity. And that's what this committee would look at, since this committee has been basically written all the immunity from prosecution laws under the so-called Good Sam law several years ago. So that's the law that I believe they're using, and we want to just make sure that the immunity we're providing is adequate for the goals of the program, but not so widespread that it would make it impossible if somebody were dealing drugs in the safe injection site, that they make sure that they are aware they don't have immunity to do that, or to bring in large trafficking sums. So, anyway, we'll be looking at that section, and Senator Lyons was aware we were going to look at it, but we had scheduled it, Ben and I had scheduled it for next Tuesday, but at the request of one committee member and the way things worked out, we will take it up in a few minutes. So, H-876 is a miscellaneous corrections bill, and we have agreed to look at the future of a women's prison in Vermont. And we will have testimony at 10:15 on that, on some of those issues. But medical care of inmates is in here, in the bill in section 1. And section 2 deals with medication, opiate use disorder in correctional facilities, and there's I believe a couple of technical changes there. As well as an effort to make it a cleaner discharge with the ability to continue the medication. Section 3 has to do with earned time reduction of term. This is evidently a fairly controversial section, and we will hear from the victims groups and others next week on this, as well as the state's attorneys. And I've already heard from some of the victims that they're concerned that they weren't really a part of this decision making. And I've also heard that the DOC may have difficulty establishing this program. So that's that section of the bill. So, section 4 of the bill is the educational credits. That's studied by the Joint Justice Oversight Committee. And then non-driver identification cards. I believe that's section pretty easy. And then the family visitation study committee report. That is section 6 of the bill. I'm just trying to do a brief walkthrough and stop me if.
Should I ask you questions?
Yes, after the walkthrough.
Okay.
And there's a committee, special committee, to look at visitation. I can remember, visitation changed a great deal over the years, and it used to be an important part of reintegration. And I don't know, Section 7 is another report. I don't.
Is this the, oh yeah, the out-of-state correctional facilities?
I'm going to tell you that number 5 on page 17 troubles me. We don't learn from our past mistakes. We had more trouble with Pennsylvania than we ever had with any of the private properties. Our inmates were more unhappy in Pennsylvania than any place they've ever been. I don't, and we forget that past. I mean, I understand the logic, I understand the opposition to privately owned for profit out-of-state correctional facilities, but the fact remains that I had more complaints about Pennsylvania than any other time that our inmates were housed out of state. And I actually held a meeting with several of our inmates who were former residents of my program, who were incarcerated in Pennsylvania, and they were, after we got through with the introductions, they unanimous that they preferred the, at the time it was Michigan under a different company. Anyhow, we'll look at that when we get back to it next week. Michelle, thank you for pitching in here. Ben, do we have copies of 72?
Yes. So
I have a copy because it came from health. No, yeah, it's health and welfare, but it's a version that passed out of health and welfare.
Appropriations made an amendment to it, didn't they?
Appropriations has an amendment to it.
Don't, but you guys aren't looking at that. You're
But
just
we're not looking at that. We're looking at, all we're looking at is
Section 1, subsection C.
thank you, section 1, subsection C, which is the immunity provisions that have been put into the bill.
Well, thank you.
Section 1.
And I think it's page 3. You see C1 on line 6 of page 3, and it goes all the way to line 17 of page 4. That's all that we're really looking at. That's our jurisdiction. So, thanks for stepping this up. We were gonna do this Tuesday.
I appreciate you doing it today. Are we on?
Yes.
Okay. All right, so we are going to take a look at the Senate Health and Welfare Amendment to H72. And I'm going to just walk you through all of Section 1 just to give you the context of it.
Okay.
And then we'll circle back to subsection C.
Yeah,
because I think
remembering that individual senators can offer changes to other sections, but the committee would be restricted to section C.
Right, but even if the committee wanted to do an amendment, somebody would, you could all go in on an individual amendment, but since you don't have jurisdiction.
Yeah, we don't have possession of
Right.
the bill, we're not taking.
Sure. So looking at section 1, this is adding a new statute in chapter 84, which is the regulated drug chapter for Title 18. And this is also where you have the Good Samaritan law for reporting overdoses that provides some limited liability from criminal prosecution under the drug laws for reporting an overdose, which I know you're very familiar with. And so this is a similar concept. You'll see on page 1, subsection A, it sets forth what is an overdose prevention center. And then there's a long list of things that it does in terms of providing a space either at a fixed location or mobile facility that's supervised by healthcare professionals or trained staff, where people can use pre-obtained drugs and medication for substance use disorder. They provide harm reduction supplies. They provide drug checking services. They answer questions on safer consumption practices. They administer first aid if necessary and treat potential overdoses. They provide referrals to addiction treatment, medical services, and social services, educate participants on the risk of contracting HIV and viral hepatitis, on wound care and safe sex education. They provide overdose prevention education and distribute overdose reversal medications, educate participants regarding proper disposal of hypodermic needles and syringes, provide reasonable security at the program site, and establish operating procedures, as well as criteria for eligibility to participate.
Can we go back to 11?
Sure.
What is reasonable security?
10, line 11, I'm sorry.
Line 11, number 10, provides reasonable security of the program site. What is that intended that there would be non-law enforcement security? Is it intended that it would be
It's not
done by
specified. I think
program
it's just,
staff or?
I think it's just plain language. If you look at subsection B, so subsection A puts out the like general parameters of what an overdose prevention center is. And subsection B directs the Department of Health to adopt the guidelines. So they're going to kind of build out the provisions that are in subsection A and provide more details for that on the guidelines. And they have to adopt those guidelines by September 15th. Then just so you know is that at a later section, what I'll say is, so for the pilot project, and Senator Sears already knows this from Senate appropriations, there's grant money that's coming from the opioid settlement fund that is going to be used for grants for the city of Burlington to offer grants for a program in the city. And so what it would be is that the Department of Health would adopt the guidelines by this fall, and then the city of Burlington would, using the criteria that's in statute as well as the guidelines, put together a grant proposal for how they would operate the OPC. And so those details are kind of expected to be in the Department of Health guidelines.
It's going to be operated by the city?
Well, the money is going to be given to the city.
Interesting. Okay.
Can be operated by a private,
Okay.
I believe a private nonprofit.
I would presume.
Okay. That's helpful.
Could
I
be
just, for a minute, I was like, it's
Could be an
city.
established like college center or something like that too, but I don't know that they know this point.
Yeah.
So subsection C on page 3, these are the immunity provisions. Again, as I mentioned, they're modeled after what you have in the Good Samaritan law, but they are in some ways more limited and in other ways more expansive. I'm going to skip over this just right now because I'm going to come back and we'll spend a bit more time on that. But if you look at page 4, subsection D, which is starting on line 18, the Overdose Prevention Center is to be providing information on an annual basis on a number of things, such as number of program participants, de-identified demographic information, number of overdoses, number of overdoses reversed on site, number of times EMS or law enforcement is contacted, and the number of participants that are directly and formally referred to other types of services. And then on page 5 in subsection E is just a clarification that the Overdose Prevention Center doesn't need to go through the certificate of need process. So going back to subsection C, on page 3, you'll see the following persons are entitled to the immunity protections. for participation in or with an approved overdose prevention center that is acting in the good faith. That's again a term that we use in the Good Samaritan law as well. Provision of overdose prevention services in accordance with the guidelines that are adopted by Department of Health. So you'll see in subdivision C1 is that the folks who would be provided with the immunity, it's an individual who is using the services of an overdose prevention center, a staff member, operator, administrator, or director of an overdose prevention center, a property owner that might be leasing a particular property to a nonprofit that's running the overdose prevention center, an entity operating the OPC, and a state or municipal employee acting within the course and scope of their employment. So subdivision 2 sets forth the.
Well, before we go there,
Mhm.
I got a couple of questions. The individual using the services of an overdose prevention center, if that individual is otherwise doing something wrong, they're not immune from that, are they? What is it they're immune from?
Right, that's what I'm about to talk about in subdivision 2.
You are?
Yes,
Okay, I'll let you do that.
okay.
Wonderful segue.
So if you look at the top of page 4, the first one is folks cannot be cited, arrested, charged, or prosecuted for unlawful possession of a regulated drug. So this does not immunize them from dispensing or selling, just for possession. Because remember, they're bringing their pre-obtained drugs to the
Possession of how
center.
much?
It doesn't matter.
Well, that matters to me.
And how far does this protection go?
So you'll see the language that is in subdivision 3, and it says applies only to the use and derivative use of evidence gained as a proximate result of participation in or with an overdose prevention center. Again, that language is in your.
Here's where I want to go with my question. I don't have I voted for this in appropriation, so it's not a problem with the bill, but the concern is that I'm assuming that the person is immune if they're carrying a personal amount. We've determined with drugs, right, the personal amount, and then we have the trafficking statutes. I want to make sure that it's only the personal amounts that they're immune from.
So I think if you look at the language in 3 where it says that the immunity applies only to the use and derivative use of evidence gained as a proximate result of participation in or with that overdose prevention center. So if someone, so the intent of that is to link it, you exclude the evidence that's gained as a direct result of them using it. So if they're, kind of walking into an overdose prevention center or they're leaving right at that time, but if they are like at home in another location, and just because of the fact that they are a participant at an overdose prevention center and does not mean that they are immunized from criminal prosecution for that. So because it has to.
Immunized. Here's my concern. It appears that they're immunized for any amount, a kilo of cocaine, they would be immunized for as long as it's in the safe injection site.
You mean if
That's
they
what
had
my-
a kilo at the safe injection site?
Are they immunized from that?
Yes.
That's the problem. And you cannot, in my mind, that's not a personal use of that. And I can remember going through this with Jim Letty when he was chair of health and welfare and I was chair judiciary. And we went through and tried to establish personal use amounts. And since then, we've taken another look. But I'm really concerned about that section of the bill. Maybe nobody would bring that amount in. But I can see character, these aren't,
I think if you had, depending if it was, but if you had a certain, once you go in those very large amounts, then you're gonna trigger the trafficking
Right,
statutes.
I know, and that's what I
but-
want
Which
to make
wouldn't
sure.
apply,
Well, but you just said they're immunized.
but only for possession, not for dispensing, selling, trafficking.
Yeah, but I don't think you're hearing me.
I think I am. I'm not arguing with you. I'm just saying that I think, so if you had a kilo of cocaine or heroin or whatever it was, there's a permissive inference that if you possess a certain large amount like that, that you trigger the trafficking. Trafficking is not covered in here, but I think probably, let's say if it was less than
I would like
that.
something expressly saying that trafficking is not, trafficking amounts are not immunized.
But if you look at the lead-in language, it just says they're only immunized
But I know
for
how those
possession.
defense attorneys work. And they will use anything they can to test whatever we pass, even if it ruins the program. With all due deference to my two friends who are defense attorneys.
Which lead-in are you,
So if you look at the top of page 4 and subdivision C2A, person cannot be arrested, charged, prosecuted for unlawful possession. That's the only criminal, aside from like search and seizure.
So
that's
what
the only
would be the
thing.
harm of adding the words personal amounts?
Well, you could certainly do that, but you would have to articulate what is a personal amount.
We
because-
already have, haven't we?
No.
I thought we did that in statute years ago.
We tried a couple of years ago in this, I think it was in this OPC study, to do that, but the governor vetoed it and it never happened.
So,
You could
That's some of the
create,
language I
you
sent you
could
actually to put
create,
miscellaneous
you could
judiciary.
say like the first and second level possession, you know what I mean? Like you could identify,
well, then
in
you
each
could, well,
statute,
you could go backwards and just say, it would be unlawful to possess amounts that are deemed to be trafficking or whatever the wording is. Think about the language.
okay, I understand your concept there, and let me think about some strategies to get at that too. Because you want it to be that they're only immunized against prosecution for smaller amounts, and then
Well, personal use amounts,
right.
but I
and
don't
then
even care if it's the weekly supply. What I'm worried about is the trafficking size. And it may never happen, but I'd like that covered in here, just in case.
Am I misunderstanding? So I thought sort of that it is covered in here because trafficking is not, you're not immunized from trafficking, and with that amount, you're automatically
No,
considered to be
You're
trafficking.
not automatically, it's
You're
that
automatically
there's a permissive,
immunized when you're in the safe injection site for any amount of the drug.
But,
Possession.
right, possession, but if you had a kilo, it triggers the trafficking and you're not immunized from that.
you're not immunized from trafficking. It's a permissive inference in the trafficking statute, which means that if you are in possession of a certain amount, there's a permissive inference that that there's an intent to distribute, and that's
I
trafficking.
just want to make it clear that we're not immunizing that big.
Okay, let me think about that. I get where you're both coming from.
The personal use definition, that's actually some of the language I was hoping to include in the miscellaneous judiciary. I sent it to you this morning.
Yeah, I haven't had a chance.
That I figured. I figured.
But I just got one follow-up question to that. How far does this immunity extend? I live on one end of the town, and I'm carrying personal use drugs, as they say. How far does this extend to the next township? I mean, are you immunized? Are you immune from prosecution because you're going to which is 3 miles away?
It could be, it's not specifically laid out, it's gonna be fact-based on the circumstances. depending on, whether or not you're on your way into there or you're leaving there, but it has to be, if you look at the language on subdivision 3 there, when it talks about only to the use and derivative use of, is that is something that we've used before and in the Good Samaritan statute, and it protects the person from the possession charge if the evidence that's gained to bring the charge is a direct result of their participation in and using the overdose prevention center. So, so if they get evidence that's obtained independently from that, that's not associated with that, they're free to prosecute the person for possession.
Senator Shi.
So I'm looking at line 15 on page 4 and the entering, exiting, or utilizing the services. And I mean, is the issue that it's going to be up to a judge to define what entering is? I mean, if you're on the sidewalk right in front of it, walking towards it at the door, obviously you're entering, but as Senator Norris was talking about, if you're in another town, you get pulled over and you say that you're on your way to the OPC, right. It's a balancing act, or that the judge has to do.
Right, it's a much harder argument to make, because anybody could say, well, I was on my way to the OPC, and they say, well, what's the evidence of that? Or are you currently a registered participant, or whatever it is.
So there's a registry?
No, sorry.
The beauty of this, actually the beauty of this is that you're providing immunity from prosecution for persons who are possessing small amounts, which police do not usually arrest for possession of small amounts anyway. If it's pure possession, unless some other crimes occurred. So that is why I don't have that huge problem. And the immunity was basically designed so that I gave you the drug and you overdosed. I can be immune from prosecution if I call and get you overdose help and recovery. So I'm not going to get prosecuted. That was the whole idea behind this. And so I have no problem with that. And you've clearly articulated that if somebody is dispensing or selling the drug at the entrance or at the exit to the safe injection site, that would still be against the law. Correct.
Right, because it only applies to possession.
But then the only other issue I have is the amounts.
The amount.
And when it gets up to a large amount, and I know I've used a ridiculously large amount, but it doesn't take a heck of a lot of fentanyl.
Right. So, should I continue?
Yep.
So, still on page 4, subdivision 2B provides protections around property seizure or forfeiture for unlawful possession of a regulated drug. Subdivision C immunizes the folks in subdivision 1 from any civil liability or civil or administrative penalty, including disciplinary action by a licensing board, credentialing restriction, contractual liability, or medical staff or employment action.
Is that civil liability from well, they don't actually. Civil liability from operating the site or doing something illegal in the site.
Right. And remember, like the lead-in language is they have to be in compliance with the statute as well as the guidelines that are adopted by Department of Health.
It's not civil liability for slip and fall because you left the floor wet.
Right.
Okay. We want to undo people's rights to sue for negligence.
Right. So on that fact, I will just mention to you that, in Senate appropriations yesterday, there was the discussion about, someone left an overdose prevention site and was impaired, and they got behind the wheel. And, this does not do anything to protect that person from a criminal charge for DUI or anything like that. But something that I was thinking of when there was a discussion there is you might want to put in some language, and I wrote some up for you around clarifying, and this is just a policy decision from you, that the immunity provisions don't apply, the civil immunity provisions don't apply to an individual who uses the services of an OPC if the basis for the civil claim is that they were operating a motor vehicle in violation of 23 VSA 1201 for DUI. So because even though this doesn't provide them with protection from a charge again for DUI, thinking about in terms of if they got into an accident with somebody or anything, and you
If
might
they
want to
hit and
clarify.
killed somebody on the street,
They can still be sued.
they would be civilly liable for that.
Right.
Would they be criminally liable?
Yeah, that's a no question.
Yeah,
I think the
that
other
should
one
be-
is
I
just,
think actually that Senator Starr, I think probably a good idea to put something in, that we're not, obviously, we're not giving you permission to drive intoxicated or impaired
right, and
any
that's
more than we would give you permission to drive impaired if you're leaving the bar.
right. And I just, right before I came in, I drafted up a little amendment for you on that, just in case
Yeah,
you wanted to
we're gonna
consider.
face that, by the way, as people, at some point, I suspect we'll have places where cannabis can be used publicly.
I think you're probably right.
And when people leave that place,
It would be interesting to look at, and I'm happy to do it over the summer, some of the other countries that
Yeah,
have had
and
cannabis.
other states.
Yeah, thinking about Spain.
That have one, that have those. Okay, Senator Hashim.
Thank you. So regarding the criminal aspect of it,
Mhm.
if somebody is leaving a OPC and, they crash their car, officer asks them where they're coming from, and they say where they're coming from, that can't be used as a building block for probable cause? The analogy that I'm thinking of
Right.
in my head is, somebody's leaving a bar, they've driven however many miles, they've crashed, they say to the officer, I'm coming from so-and-so bar, that's not, that's.
Right, I don't think
Yeah.
they would be precluded from that, because when you're talking about the use and derivative use, you're talking about how that applies to the possession charge,
Yeah.
because they're only being immunized for the possession charge, so everything else is open.
Okay.
So if somebody goes out and shoplifts or does anything, they can't then say, oh, well, I just came from here and
Right.
I'm under the influence and therefore you can't use that against me.
Just wanted to make sure. Thank you.
No, you still have to prove they were under the influence. I mean, the police officer can't just say, well, because you were there, you were under the influence.
Right.
That would be clear, hopefully.
Yeah.
It'd be the facts of your current state as you were exiting the vehicle after you crashed into two parked cars.
And then the last one on subdivision D, denied any right or privilege, and that's language that came from the Vermont Medical Society. I think they're looking out their providers there, making sure that if they have practitioners who are licensed or employed at a hospital and they're volunteering or staffing a site, that they are not punished for their association with the Overdose Prevention Center.
So if you can prepare those two amendments.
Okay, I have the one, I actually,
Question about
Yeah.
the denied any right or privilege. Does that protect their employment? So if I worked for the UVM Medical Center, but I volunteered at the OPC on the weekends, could UVM fire me?
well, you see up here in subdivision C, is it talks about contractual liability, medical staff, or other employment action.
So no, okay, just wanted to make sure that that was protected because I don't know that we have guaranteed employment as a right.
Mhm.
So thank you.
So I just, when Ben just told me he wanted, I thought of this amendment when we were
Yep.
talking about it in Senator Prost, but I thought we were doing it Tuesday, so I just put it on some paper real quick, but, and
Well, we
Ben,
still don't have it until,
right.
I don't think Ginny had a particular problem with waiting until
Right.
Wednesday.
So, but just so you can take a look at the language that I just drafted up on the issue of just clarifying that, once somebody leaves, they get into a vehicle accident, somebody else is injured, then that's not, they're not going to be immunized from civil litigation in that particular circumstance. And so can I, if we have a little time,
Yeah, we do.
can I just talk to you a little bit to get a little more guidance on, the threshold amounts for the
Yeah.
limitations?
Personally, I'm only concerned with trafficking.
So Senator Sears, does it make sense to you to just explicitly name that the person is not immunized from trafficking a controlled substance?
Well, I would think that,
But the thing is that it specifically says they're only immunized from a possession charge. So I don't want to say that they're not
Okay.
immunized from trafficking because they're not immunized from anything but possession. Do you know
Right.
what I mean? So
well,
it
but I
kind of,
thought, I'm sorry, but I thought that if you think that they're not immunized from trafficking.
they're not.
Okay. So do we make that explicit or do we just leave it?
I wouldn't add it because then when you put that in, then
Then
it
you have
kind
to
of
name everything
causes
else.
questions about everything else. And I think the plain language clearly says that you're only immunized from an unlawful possession charge. But to your point, Senator Sears, is I just wanted to pull up maybe one of the drug statutes and give you an amount, like under possession, and see, not that we all necessarily even know how much these are, but,
Well, we know that 50 pounds of cannabis is trafficked.
right, somebody'd have to come in
So-
with a wagon.
So, well, let's just, I realize that people would be able to see the 50 pounds of
Right.
cannabis.
I was thinking
But would
about,
they be immune, if they had a small amount of heroin that they were going to use for personal consumption, and they brought the 50 pounds of marijuana in? Are they immune from prosecution on the 50 pounds of marijuana? I know it's a ridiculous.
they would be immune from a possession charge. However, if you had 50 pounds of marijuana, they could say under the cannabis statute, and I'll read that to you.
Recognizing out there in YouTube land, this is a ridiculous example. Trying to understand how this would work.
So trafficking of a person knowingly and unlawfully possessing 50 pounds or more of cannabis or 5 pounds or more of hash with intent to sell or dispense, and then it's a 30-year penalty.
But I thought that was a permissive inference,
Yeah,
that
but-
if you had that amount.
Right, there shall be a permissive inference that a person who possesses 50 pounds or more of cannabis intends to sell or dispense it. So remember our discussion of permissive inference, it's not, it means that the fact finder, can infer that your possession of 50 pounds means that it's not all for personal use and you have an intent, and they can use that as evidence, the amount as evidence. So they can charge you under trafficking, but they can't charge you under the possession.
Under C, the
Right,
person could be charged for
trafficking, yes,
but not for possession.
correct,
And I don't care, as long as they can be charged with trafficking.
yes, they can.
Okay, so you're confident in that?
I'm confident they can be charged with trafficking. Let me look at the amounts where you have the other trafficking. The other
Yeah,
trafficking.
more likely would be heroin or fentanyl or some other. Or
Cocaine.
we don't have a fentanyl, do we?
Mm-mm. Trafficking for cocaine is 150 grams. For heroin,
It's 200 and something,
it's 3.5 grams.
3.5.
And in any of these instances, if I went in, I couldn't be charged for possession, but if I had that amount, I can be charged for trafficking.
Yes.
So,
So I think.
I
it's
mean, that
possible.
you could be charged and then there's a permissive inference that you had that amount and therefore you had an intent to distribute. You could the defendant could counter and say, no, actually I've been using for 20 years and this is my weekly supply and I use a lot. I don't know. I don't know enough about
I don't know enough
the
about the
amounts
amounts
and where they
either.
are, so to really, know, and that's,
who would like their name on the amendment that,
oh, sorry, I just
draft
put yours.
1.1?
I'm happy to have my name on the amendment.
Pardon me?
I'm happy to have my name on the amendment.
Senator Bahowski, Senator Sears, Senator Sheen.
Yeah, that's,
I'd rather not be associated with any part of this.
And you don't want to be associated, even the hard part?
The hard part?
Yeah.
What's the hard part?
And make sure that if you're driving impaired, you can't use that as an excuse. Okay.
No.
Would you offer to Senator Sears, Bahowski, or Senator Sheen, Sears, Bahowski, whatever the
Yes.
order is. And we could have it for Tuesday on the,
Okay, and then
on the calendar so they
right.
can vote on it Tuesday if they want.
And I do want to think a little more about the issue raised, like a slip and fall and things like that, and whether or not maybe we need to just add some language there around belts and, suspenders to kind of make sure that that
Yeah, I
any
think
types
we
of things
really
like
need
that
to
to
make
spell
sure
it
that,
out.
The facility doesn't maintain itself in a proper manner and leaves, something vulnerable. And the person is leaving in falls on the wet pavement, they shouldn't lose
Right.
their right to sue.
Right. So and I'll talk to Eric, because he typically does that kind of civil liability stuff. So I'll talk with him and I'll play around with some language, so when I come back on Tuesday, I'll add the other senators' names, and then I'll look at playing around with some
So
language on
we're
this,
still
on the slip
planning
and
on
fall.
passing over on Tuesday? Or we could do second reading if you can get this to us, and then we could do the slip and fall
On third reading.
on third reading.
So you want to do two different amendments?
Well, I could do
Like
one,
two separate?
it depends on how quickly you can do. Well, why don't we just, Jenny was fine with passing over, are you okay with
I
that?
really don't want to.
Well,
I mean, I was just thinking rather than do two, I mean, you might get questions on it, and
Yeah.
then,
But we can do all of it on third reading.
I'm just saying that if these issues come, it's up to you, however you want to
Okay.
handle it. It's your decision. I'm just
I'm
thinking about, it's
anxious about this bill. I
better to
just want
get
it
in front
go.
of it, but
so the question is whether we're doing two separate amendments
Or
for,
whether we pass over the bill on Tuesday and do it on second reading on Wednesday, and I
the
really
plan
don't want to
was,
pass over the bill.
until Ben got sick, the plan was to pass over H-72 on Tuesday, to give us a chance on Tuesday morning to go over the bill and then make any recommendations for changes with the Health and Welfare Committee so they could meet on our changes on Wednesday morning. And then we'd go with second reading on Wednesday. What Senator Bahowski is anxious to have the bill get passed, so she would like to do second reading on Tuesday and then do our amendments, I assume, to have them ready for third reading, which we would then give to the Health and Welfare Committee on Wednesday morning so they could look them over.
Yes,
Is that articulated?
you did it perfectly.
So,
I think second reading is good.
so we would wait on our amendments until Tuesday. We'd have them Tuesday morning to discuss in here for a few minutes. I'm assuming they'd be written, and we'd have it ready, and I would give them to Senator Lyons, and we'd do it before third reading. If Senator Lyons wants to do it on Tuesday, she's probably more prepared now to do it on Wednesday because of our.
I will talk to Jenny and tell her that it's my fault.
Yeah, just take them,
I will.
don't slip and fall on the way.
I will try not
We haven't
to,
determined yet whether that's,
although I am wearing ridiculous shoes, so it might be partially my fault.